Hey everyone, thank you all for joining us this afternoon. My name is Christiana Krupa and I'm the NAGPRA officer for the University of Illinois at Urbana-Champaign. And we're really excited to have you all here with us to talk about the Native American Graves Protection and Repatriation Act, or NAGPRA, and its implementation in Illinois and at the University of Illinois and the Illinois State Museum specifically. So we're really excited to have you all with us for this joint training. And to explain a little bit about how this is going to work, I will introduce the other lovely folks on your screen right now. They'll all say a few words, and then we will go ahead with our presentation from Melanie O'Brien, after which there will be a moderated Q&A period. So the way that the Q&A period is going to work is that you all have permission to send the chat messages in your chat feature directly to the hosts of the meeting. And I will be asking your questions out loud directly to Melanie. So when you send your questions in through the chat, please set them to go directly to me. My name is in the bottom corner of my video, of course, so you should be able to just check for that name in the list. But I will remind everybody how all that's going to work again after the presentation and before we get started with the Q&A. So now that we mostly have the logistics out of the way, I would like to introduce Chancellor Robert Jones from the university here to say a few words and get us started. Chancellor, thank you so much for joining us.
Thank you, Christiana. As a land-grant university, land-grant institution, the University of Illinois at Urbana-Champaign has a responsibility to acknowledge the historical context in which it exists. In order to remind ourselves and our community, we will begin this event with the following statement. We are currently on the lands of the Peoria, the Kaskaskia, the Piankashaw, the Wea, the Miami, the Mascoutin, the Odawa, the Sauk, the Meskwaki, Kickapoo, Potawatomi, Ojibwe, and Chickasaw nations. It is necessary for us to acknowledge these Native nations and for us to work with them as we move forward as an institution. Over the next 150 years, we will be a vibrant community inclusive of all of our differences, with Native people at the core of our efforts. Here at the University of Illinois, we begin our most important events with that land acknowledgement statement. And we do it because it's important for all of us who become part of this university to truly understand the past and the people who came before us and who had a historical role in shaping this place that brings us all together. It is especially appropriate to use that statement to welcome Melanie O'Brien and to open today's program on NAGPRA. As a university, we have a particular obligation to honor, respect, and consult with Native people in every aspect of our educational, engagement, and research missions. Our compliance with both the letter and the spirit of NAGPRA regulations is a cornerstone of the commitment that we have, and that this will be a permanent priority for this institution. I am so very pleased to be joined today by my senior leadership team, as well as we are all looking forward to this opportunity to learn how the university, and in fact, the entire state, can be true leaders in moving forward in this critically important, collaborative, restorative, and respectful effort that's underway. So on behalf of the entire University of Illinois Urbana-Champaign, just want to thank you all for joining us. And thank you, Melanie, for bringing us your expertise, your advice, and of course, your guidance. Thank you so much.
Excuse me. I did the thing and forgot to unmute myself. Thank you very much, Chancellor. I mentioned that this is a joint training between the university and the Illinois State Museum. And so I would now allow our co-host to introduce herself. So Cinnamon, whenever you're ready.
Thank you, Chancellor, and thank you, Christiana. My name is Cinnamon Catlin-Legutko. I'm the director of the Illinois State Museum. And I'm speaking to you today from the same ancestral lands previously mentioned. And I also want to acknowledge the 100,000 Indigenous people who live in Illinois today. I'm looking forward to today's webinar because the ISM, which is part of the Illinois Department of Natural Resources, is actively engaged in the work of Nagpra. Repatriation in Illinois has been slow, and it's time to make up for lost time and create a better future for indigeneity in Illinois and for tribal collaboration with organizations like the ISM and the University of Illinois. As the new director of the ISM, I keenly feel the urgency for us to actively work to repatriate the nearly 7,000 ancestors in our facility. Our repatriation efforts prioritize Indigenous concerns and move beyond archaeology as the primary determinant for lineage, just as NAGPRA legislation specifies. We also need to reconsider, in collaboration with tribal communities, what it means to have a state museum facility at Dixon Mounds, rather on top of a sacred burial site. There's much work to do. I'm here today also to learn more along with my colleagues from the Illinois State Museum and the Department of Natural Resources, serve as a resource for the agency, and of utmost importance, continue to deepen my commitment to resolving this human rights emergency. Thank you for joining us today, and I'll hand it back now to Christiana.
Thank you, Cinnamon. I'd like to echo everything that she just said and say that we're very excited as a university to move forward in our NAGPRA efforts with the Illinois State Museum. So now it's my great pleasure to introduce Melanie O'Brien, who is the director of the National NAGPRA Program, who has graciously offered to speak with us all today about how we can move forward with our NAGPRA efforts in Illinois. So I will go ahead and pass things over to Melanie, who can say a little bit more about herself and then go ahead and give us a wonderful presentation.
Thanks, Christiana. And thank you, everyone. It's wonderful to be here virtually with you. I do wish that I could be there in person with you. I find these virtual meetings to be wonderful in being able to reach a broader audience, more people at one time, but I really miss the opportunity to engage face-to-face with people. As Christiana said, my name is Melanie O'Brien, and I am the manager of the National NAGPRA Program, which is within the Department of the Interior in Washington, DC. I am coming to you from my home in Maryland, just outside of DC, and I could give you a similar land acknowledgement of my home here on the lands of the Piscataway people, but instead, I prefer to start meetings like this by giving a bit of a personal acknowledgement. I was born and raised in Independence, Missouri, so I'm a Midwesterner by birth. Independence, as you may know, is the home of Harry Truman and the Three Trails West. So I grew up every Labor Day putting on a pioneer dress my grandmother made me and celebrating Western expansion through something we called Santa Caligon Days, standing for the Three Trails. My family purchased land in the western parts of the United States, in Indiana, Michigan, and Missouri, very early in the 19th century, and were farmers and early settlers in all those states. So I come to this work really from a very different perspective than many people who engage in this work, maybe a perspective similar to some of you who have spent your lives and careers dedicated to the history of Western states and Western expansion. That's certainly the background, my own personal background on these issues. But I see this as a real opportunity, and I have struggled over the years to try to explain exactly what I see as the opportunity here. And thankfully, since January 21st, I found a poet laureate who put these words together, which has made it much easier for me to express. Amanda Gorman, the youth poet laureate who spoke at the inauguration a few months. I think I got muted accidentally. Can you hear me?
Yes, we can hear you, Melanie.
Okay. So Amanda Gorman, the youth poet laureate, said in her inaugural poem that being American is more than the pride we inherit. It's the past we step into and how we repair it. And so I fundamentally see the work that I do on behalf of the federal government, on behalf of the people of the United States, as an effort to repair the past that I personally and professionally have inherited. So I'm going to share my screen with you. What I have prepared today is a short presentation to go over some basics on NAGPRA, but I wanted to be sure we had plenty of time for Q&A. So basically have 4 parts for this presentation today. And I like to start my presentations by talking about sources and resources. Everything that I'm going to tell you today, you can look up for yourselves. There's nothing I'm going to share with you that you can't find in the sources and resources we have about NAGPRA. Thankfully, we have all of these sources on our website. You don't have to go to a library to find them necessarily. On our website under Law and Policy, you can find a copy of the Native American Graves Protection and Repatriation Act. It's fairly short. I would highly encourage you to read it. Along with that are the 2 central pieces for understanding what Congress meant when they passed this law in 1990. And those are the 2 reports, the House report and the Senate report, that explain more about the intent behind the law. And again, I'll share these, the presentation out afterwards, and you can have access to all these links. But again, you can get to it from our website. The second piece that is important to understanding NAGPRA are the regulations. And regulations interpret and explain the law by providing a specific process. And on our website, you can find both the proposed rules as well as the final rules that provide a lot of input into the decisions that the Department of the Interior, where I work, made and how it interpreted the law. And of course, you can find the current regulations on our website. And the great thing about these is that they're all publicly available and text searchable. So if you're interested in a particular question about NAGPRA, you can query those documents and try to find an explanation for it. So a lot of times I would end my discussion with sources and resources, but I like to start with that because I want you to know that everything I'm going to tell you comes from those documents. So let's start with the pillars of the law. What are the central features of NAGPRA? And again, this is a pretty high level look at the law and the process. Again, turning to the congressional intent, it is very clear from both the House and the Senate reports that the purpose of NAGPRA is repatriation. And while there's a process to achieve that, central to both the House and the Senate report is a clear statement that the purpose of this law is to repatriate remains and objects. So there are basically 3 principles that the law provides for repatriation as the goal. The first is an agreement. There is an ongoing obligation for museums to consult and to negotiate an agreement on repatriation or disposition of remains. Congress did this intentionally so that there would be a process built into the law to facilitate this work and to promote consultation and ultimately achieve agreement between museums and tribes. The other central pillar of NAGPRA is transparency. NAGPRA requires museums and federal agencies to provide descriptions of all of their Native American collections, both human remains and objects, so that tribes can know what exists in museums and can work towards requesting them for repatriation. And Congress, again, intended this to be an effort to force an exchange of information between tribes and museums regarding those objects. And the last pillar is really about making connections. NAGPRA requires museums to look for and determine if there is a relationship between human remains and present day peoples. And in doing so, what Congress intended was that there would be a reasonable connection between these items from past cultures and people and the present day peoples. So with that as a foundation of what the law intended and how it attempts to create it, I'd like to look more specifically at the step-by-step regulatory process. Basically, NAGPRA requires three things. It requires consultation, identification of Native American collections, and then providing notice, public notice, prior to repatriating or transferring items. That's boiling NAGPRA down into its very simplest pieces: consultation, identification, and notification. So to talk a little bit more about each of those three things, I've prepared this as a look at what must be done and what may be done, emphasizing that there is discretion in the decision-making responsibility that museums have. So the requirement for consultation is that a museum must consult with tribal land or Aboriginal land tribes within 90 days of receiving a request to do so. That means that there is always an obligation on any institution that holds Native American human remains to respond within 90 days of a request. Museums must seek to develop a proposal for disposition, and they must offer to repatriate or transfer human remains. Those are the requirements, ongoing requirement for museums to consult with tribes on any collections. So to reduce this ongoing obligation, there are some things a museum may do. And a museum may initiate consultation itself, absent a request. A museum may collaborate with other museums, especially on shared collections, to reduce that ongoing burden. And a museum may provide written policies of when and how they're going to make decisions, again, to further reduce this consultation burden that exists, whether a museum takes these actions or not. Again, looking at the connection between the process, the identification part, creating an inventory or a summary. That is an effort to ensure that there is transparency. So a museum must identify geographical and cultural affiliation of objects in its collection. A museum must use available information, and a museum must provide clear descriptions for the purpose of repatriation to facilitate those requests. So those are the things a museum is obligated to do. Most museums took care of this obligation by filing initial compliance documents in 1993 and 1995. But there is an ongoing obligation to ensure that additional information is provided when available. So in order to avoid a possible failure to comply, a museum may identify all of its Native American items, regardless of whether they're sure it might fit a category or not. We recommend at the Department of the Interior that a museum be as broad as possible because you don't know necessarily what object a tribe may identify as a cultural item under NAGPRA, and therefore you will have failed to comply if you haven't identified that. Proactive communication with tribes to provide them with information is again an option for museums that can really help to smooth a path forward and ensure full transparency in the process. Likewise, ensuring that all compliance documents are updated as new information is available or as new collections are identified ensures that there's no chance that a museum may have failed to comply with the requirements of transparency and identification under the law. So lastly, cultural affiliation and how a museum must, the actions a museum must take in determining affiliation. A museum must use a reasonable basis using all available information, including consultation, and that there is no requirement for any exhaustive studies or precluding a connection or affiliation because of a lack of information. These are all the basic requirements of identifying affiliation. Now, what a museum may do is exercise its discretion by identifying just 3 pieces of information. This is all that's at the base required to identify cultural affiliation under NAGPRA. And that is there's a present day tribe, there's an earlier group, and that there is a relationship of shared group identity between the present day people and the past people. A museum has discretion in how it applies or how it recognizes this connection of cultural affiliation through time. To give you an example of how many museums have determined cultural affiliation, I've drawn up this graphic, which represents a lot of cases across the United States, where there might be a cultural item, human remains or objects, that are connected to one or all of these 3 earlier groups of people. And as you can see in this hypothetical example, the first earlier group is sort of connected, although there are gaps in that connection, to 3 present day tribes. The group 3 is connected, again with gaps, to some present day tribes. And maybe for group 2, there is no connection. But if there is a connection between these earlier groups, it stands to reason that there is then a shared group identity between all earlier groups and all of the present day tribes. Nothing in NAGPRA would preclude a museum from determining cultural affiliation between an object from this 5,000 year period, or human remains for that matter, across any point in this 5,000 year period, to culturally affiliate those with all of the present day tribes identified here. This is certainly an example of what we have seen in affiliation by other museums, and it is certainly an acceptable application of the statute and the regulations. So after kind of a broad overview of what the process is, about why the process exists, the intent here of Congress, I'd like to look a little bit at where we are after 30 years of NAGPRA. So again, thinking about that regulatory process and the 3 pieces of it: consultation, identification, and notification. Most museums and federal agencies across the United States have satisfied the second requirement, the identification and reporting of Native American collections. But where museums still have work pending is in consulting with tribes upon request, or initiating that consultation themselves, and then giving notice. So where we have identified Native American human remains or cultural items that have been reported to my office, to the Department of the Interior, but are still pending consultation or notification under the law, we've categorized those as still pending the regulatory process. There's still work that must be done on those collections. So in looking at those collections which are pending versus those that are complete or have completed the regulatory process, here's a view of the United States. And this is based on where human remains were removed from. And these are effectively those states that are darker are places where there has been more repatriation or more completion of this NAGPRA work, more completion of the regulatory process. We can compare this map to the map of those that are still pending in repatriation or pending in the regulatory process. For sake of your view, I've cut out the Alaska and Hawaii data from this picture. It's important to know that there is work in those places as well, but I've just simplified the map for our purposes today. So you can see that Illinois ranks #1 as the state that still has the most pending human remains under the NAGPRA process. So 13,000 Native American human remains are still pending notification, and consultation under NAGPRA. So if we look a little closer at the top 10 institutions that have pending collections, you'll see that Illinois State Museum is there on the list, as well as Indiana University. The University of Illinois Champaign-Urbana is a little bit further down on this list of those that are still pending work or pending the regulatory process under NAGPRA. I ran a couple of reports, and I'll say that this information is all publicly available. I can provide a link to the Tableau website, which is the visualization for this data. This is all data that's been collected by my office over the last 30 years, and we've put it together in these visualizations to make it a little easier to see. So I ran a report for those collections that were removed from the state of Illinois and then where they're located. So as you can see, most of the remains that were removed from Illinois stayed in Illinois. The second largest collection is just next door in Indiana. But you might be surprised to see how far remains that were removed from Illinois have journeyed. So you can see that there are about 276 sets of individual Native American human remains that were taken from the ground in Illinois and are currently residing in Massachusetts. Likewise, you can see all the way over to the West Coast that there are 22 sets of Native American human remains that came from Illinois in museums in California. So it just gives you a little bit of a view of how widely the remains from Illinois have spread across the United States. Likewise, if we look at those collections that are in Illinois, either Illinois State Museum or the Field Museum in Chicago or other locations in Illinois, some of those human remains are not from the state of Illinois itself, but come from very far afield, like the 397 ancestors from Arizona that are now currently in Illinois. So you can see there's both a connection of Illinois remains leaving the state and then remains from other places coming to Illinois. I think it's interesting to look at the comparison of these two maps. As you can see, there's some similarities here between collections and where they went and collections that have come to Illinois. And I would suggest that there's an opportunity here for some reciprocal agreements between institutions like the Illinois State Museum and the University of Illinois to work with partners in other states and to maybe have some agreements where those remains can go back to their places of origin or to come back to Illinois. And this is not an unusual thing. I will say that many museums in other states have been working towards bringing back remains that are from their state and bringing them back for the purposes of repatriation. Just over the last week, there's been a lot of news coverage over some repatriations out of Mississippi. The Mississippi Department of Archives and History, which is the state museum for the state of Mississippi, also just produced a NAGPRA website that provides more information about their efforts, and in particular their efforts to find collections that were removed from Mississippi and to work with other museums in other states to bring them back to Mississippi. There's been similar efforts in Ohio, and then in California, there's been a very aggressive approach by the state legislature in California to expand repatriation and to expand the requirements for repatriation of remains from California. So I would suggest to you that Illinois has a lot of opportunities as well as some challenges here. In preparing for this presentation, I did a bit of reading on the history of archaeology in Illinois and certainly about Dixon Mounds. And I was fascinated by this quote that was from a periodical, Illinois Issues, from December of 1990. And this quote from Judith Frank, who at the time was the director of the Dixon Mounds, in responding to criticism over the closure of Dixon Mounds in January of 1990. And I thought this statement was very significant and had a lot of resonance to the situation Illinois finds itself in today. I think that there is an important opportunity here for the state of Illinois to see the trend that is occurring across the United States when it comes to repatriation. And in particular for the Illinois State Museum and the University of Illinois to recognize the opportunity that they have to really take on a leadership role in serving all of the people of Illinois, both past and present. So a couple of the challenges that I see for Illinois and for collections from Illinois. Clearly, there is a sizable collection. We know that there are at least 13,000, but probably more sets of individual human remains that are still pending in this process. Obviously, there's a challenging past relationship with tribes that have been removed from the state of Illinois. I would guess that there are also a lot of issues for Illinois institutions in unraveling control, questions of who controls which collections, both within the state, but also within federal collections. And again, based on some of my reading in preparing for this, I realized that there is a challenge to the archaeological record in Illinois, and that there are a lot of people, present day people, who are connected to a lot of parts of Illinois history. But I would suggest to you that those challenges could be really opportunities. I would say that Illinois State Museum and the University of Illinois really have the opportunity to take on some regional leadership and support other museums and tribes in working towards the repatriation of ancestors from Illinois. In many cases, small museums across the United States have human remains from Illinois, and it is a real opportunity for the Illinois State Museum, in particular as the state agency, to serve all of the people of Illinois by assisting in the repatriation of those collections. There's a great opportunity here to improve and enhance relationships with Indian tribes, as well as local communities, in better connecting to the past people of Illinois. Ultimately, by taking a proactive approach to this process, any museum could reduce its ongoing obligation to respond to requests from tribes and to undergo this work within the constraints of the regulatory timeframe by taking a more proactive approach. And lastly, I would say that there's a real opportunity here to practice some restorative justice, to make amends for the past practices, but also for building a brighter and broader future for people in Illinois and for these institutions. Again, you can find a lot more information on NAGPRA, a lot more specific information on our website, nps.gov/NAGPRA. And of course, you're always welcome to contact me directly or my staff. We are, as I mentioned at the beginning, usually in our offices in Washington, D.C., but have been teleworking. So you can always reach out to us either by phone or email, and we'd be happy to assist you with any issues you might have with NAGPRA. So with that, I'd like to go back to Christiana and take some questions.
Thank you, Melanie. I think you've certainly given us a lot to think about. And in that vein, We would love to know some of the things that you guys are thinking about. So we can now open it up for our Q&A period. And just as a reminder, the chat is only open to participants sending messages to hosts. So for me to be able to read your questions out loud for Melanie to answer, please open your chat menu and go into the drop-down list and select my name so that I can read those for you. We already have one that I think is a really great question. Melanie, can you talk a little bit more about how a museum is defined under NAGPRA?
Sure. So a museum under NAGPRA is any institution, including institutions of higher education, that receive federal funds, either directly or indirectly, and have control of Native American cultural items or human remains. So really, as long as there's a connection to federal funding, again, directly or indirectly, and there's a presence of Native American collections, it's very likely that that institution is a museum under NAGPRA. Some examples of museums under NAGPRA include the Dallas Water Utility. So receipt of federal funds through county and city funding, and collections of Native American human remains because of excavations and other activities. Made the Dallas Water Utility a museum for purposes of NAGPRA. State police offices sometimes have NAGPRA responsibility depending on if they have collections. County coroners sometimes have NAGPRA obligations if again, they have Native American collections and have a receipt of federal funds. Most universities have a receipt of federal funds. Most small historical societies have some form of federal funding that comes to them either through, say, a state library grant that is coming through the Institute of Museum and Library Services, which is a federal agency. So there are many ways in which institutions might receive federal funds and are likely then subject to NAGPRA.
Thank you, Melanie. Our next question is, let's see here. Can you speak to what the results of those 3 actions have been, which are, I think the consultation, identification, and notification that you mentioned? Have agreements been made between tribes and museums to reclaim remains, to allow museums to keep the remains for a certain time, et cetera? Do you have any case studies of how this has played out?
Sure. I think any variation you could think of, I have heard about. There's certainly been instances where through consultation, tribes have agreed to accept legal control of a collection, but have decided to leave it at the museum. In some cases, they've left it at a museum or a university intentionally for there to be additional study or research conducted. The significance of NAGPRA is that it's about resolving who has the right to those collections. And once the tribes have the right to the collection, the tribe can then decide to do whatever it wants to with those collections. So there are certainly many examples where collections have stayed in a museum and in some cases even been allowed to have research conducted. But the key under NAGPRA and the purpose of the repatriation is to allow the tribes to make those decisions.
Our next one, I really like personally, says, what are some strategies for a museum to explain NAGPRA to members of the public who might not be on board with the process?
Sure. Well, I think that the easiest way I've found to explain NAGPRA to any average person is to make a connection to their own family. You know, we have as a general common law practice that individuals have rights to determine what happens to their family members once they are deceased. And in general, none of us like to think about our grandparents or our great-grandparents and the disruption of their final resting places. And in fact, states have significant laws that protect burials of individuals. But what's happened in this country for about 100, 150 years, maybe longer, is that Native Americans haven't enjoyed that same right to the protection of their ancestors, to the protection of their grandparents and their great-grandparents. And so what NAGPRA does is tries to restore that right to them.
Thank you. This one asks whether federal museums are subject to NAGPRA.
Yes, any federal agency is subject to NAGPRA and is required to undergo the same process of consultation, identification, and notification. The one exception is the Smithsonian, and that's because the Smithsonian functions under its own repatriation requirements that predate NAGPRA. Under the act that created the National Museum of the American Indian, all Smithsonian museums are required to do a repatriation process that's very similar to the NAGPRA process, but is outside of it.
Our next question asks whether you can speak more about publicizing when repatriations occur. I'm not quite sure whether this question means overall publicity or notification. It says, does that simply mean posting the repatriation on a website? I understand that some tribes prefer to not have repatriations publicized.
Yeah, so notification really means a publication in the Federal Register, which is like a daily newspaper for the federal government. And the requirement under NAGPRA is to place a notification in the Federal Register prior to repatriation. And that's really to ensure due process, to ensure that everybody's aware of the decision a museum's making and who they intend to repatriate to. That's the extent of public notification that is required. Beyond that, whatever press release or publication or publicity might surround a reburial or a repatriation is really something up to the tribes and the museum. Some tribes are very open about the process. The image that I used at the beginning of our presentation and the one that's at the top of our website is a reburial at the Saginaw Chippewa Reservation in Mount Pleasant, Michigan. And the photos were done by a professional photographer for the tribe who gave us permission to use them. And so in that case, those tribes had no issue with publicity. They issued their own press releases. They allowed photography. But again, that depends greatly on tribes. I know in the case of the recent Mississippi repatriation, there were quite a few quotes in the news articles from the tribes. And I think that that reflects an involvement with the tribes in determining what kind of publicity is appropriate.
Next, we have a question that is a component of the law you didn't really talk very much about, which is inadvertent discoveries in the field. Could you say a little bit about that?
Sure. So NAGPRA provides for a process where Native American items are discovered on federal land or on tribal land. So for federal agencies and for Indian tribes, there is a process that's required if any discovery is made on those lands, on lands controlled by federal agencies or by Indian tribes. If we're talking about discoveries on state land or private land, that decision about what happens to those collections really falls to state law. And state law will determine what happens next and whether those discoveries become part of a collection that are then subject to NAGPRA and must go through the same identification and consultation process. Or if there's some other alternative built into the state law that provides for what happens in the case of a discovery. And that varies. Each state has a different set of state laws and prescriptions around what can or can't be done with any discovery on state or private land.
That actually segues really nicely into our next question, which is, what is the role of the State Historic Preservation Office in NAGPRA implementation?
Well, in general, it's the State Historic Preservation Office that manages that state law or the application of that state law, whatever it might be. I can give an example of Missouri because that's where I'm from. Just a few years ago, my parents and I found a family cemetery on private property. And because of the way that state law works in Missouri, we had to register that private cemetery, ensure that it was listed with the state so that it can be protected and then eventually perhaps be turned over to the state. And so the state law prescribes what happens not only to my family cemetery, but to any unmarked or private cemetery that might be on private land. And it is the SHPO's office that coordinates both the recording of that cemetery, but then any activity that might occur on that property, private property, and any remains that are discovered, state law determines and the SHPO's office determines what happens from there.
Thanks. Our next question says, could you clarify what categories of materials are subject to NAGPRA? Is it only related to mortuary sites, or does it include all Indigenous sites, including habitation and mortuary features?
Sure. So any Native American cultural item that meets a definition under NAGPRA is subject to consultation and repatriation under the law. So there's a priority in the law on human remains and funerary objects. So anything from a mortuary setting. But then there are other categories of objects as well, and those include sacred objects or objects of cultural patrimony. And those might come from any number of locations and any different kind of location, not necessarily just from a funerary context. So certainly any Native American item needs to be viewed with the possibility of a request for repatriation. And as I suggested as a best practice for a museum or an option for a museum, is to go ahead and be clear and transparent about all of your collections so that you don't run the risk of having something that a tribe can identify as being a sacred item or being an object of cultural patrimony. And then the museum has failed to comply because they haven't listed that in a summary. They haven't notified tribes that they have a collection related to their tribe. And that can lead to civil penalties or failure to comply.
Thank you for that clarification. Our next question is, what if the ancestral remains were removed from private land and transferred by a private collector to a university as a loan?
So again, state law would need to determine whether that private individual under state law can retain control of human remains. Some states don't allow for individual private citizens to retain control of human remains, and therefore those would have to go under some other process. If items are on loan to a museum, typically the museum or university in this case does not have control. And so they would not be able to then carry out the NAGPRA process. We're seeing a lot more instances of private collections. In many cases, say a grandparent who collected something 10, 20, 30, 50 years ago and has had it in a box in the basement. And as that the person passes away, the children are left to decide what happens to these collections or these private holdings, and quite often don't want to retain them. And so, finding a way forward for those collections is often giving them to a university, making a donation. Those are certainly options. And we would encourage a museum in that case to accept responsibility and to ensure a better outcome for those human remains from a private collection, rather than for them to be disposed in some other way that is not respectful. But whether or not a museum has an obligation for that private collection really comes down to what are the terms of a loan, how it's documented, and then certainly if that private individual has the ability to control those human remains themselves under state property law.
Does NAGPRA have any ability to address institutions and public places that are built on sacred sites?
It's a good question. So NAGPRA only applies to those things that are actually removed from the ground. So in the case of, say, a building that might be on top of a burial site, there wouldn't necessarily be a NAGPRA application. There would probably very likely be an issue related to the National Historic Preservation Act and the state's responsibility for preservation of archaeological resources. So there might be a connection there to the SHPO's responsibilities for archaeological resources. But there's no NAGPRA responsibility until the remains are removed from the ground. I will say the one exception to that is that NAGPRA does have criminal procedures in it, which prohibit anyone from using Native American human remains for profit. So if a museum were to charge people to come and look in a hole in the ground, that could ultimately be a criminal violation of NAGPRA. So there may be a way in which even remains that are still in the ground might violate some aspects of NAGPRA, but in general, until those things are removed from the ground, NAGPRA does not apply.
You also mentioned challenges with control of federal collections. Under what circumstances would control, and therefore responsibility, be transferred from one agency or entity to another, and how?
It's a very good question, and it's a pretty challenging one. In general, anything that is removed from federal land, from land controlled by the US federal government, would be federal property, and therefore NAGPRA responsibilities would fall to the federal agency that controlled that land. There are some exceptions to this and some issues that have been identified around perhaps when the excavation occurred and whether or not the federal agency had control of those collections at the time that they were excavated or removed. It's really a case-by-case analysis that has to be done, which is why it can be so complicated. But a best practice for a museum or university that has collections that they're unsure about is to be sure you're notifying that federal agency that you have these collections, because in a lot of cases, federal agencies don't even know that they exist or that the collections have landed wherever they've landed. And so making them aware of that so that you can resolve the issue of control long before there's a request for repatriation, because the last thing you'd want to do is have an issue of control get in the way of providing your ability as a museum to respond quickly and to know that you need to respond for some collections and that the federal agency needs to respond for others. So there's a real advantage to museums to resolving issues of control as best they can. And really NAGPRA was enacted in many ways to help resolve that issue. So if there's still a question after 30 years about who has control of collections, it really should be a top priority.
What have you found to be primary constraints for those states which have identified remains and objects, but have yet to complete the consultation, notification, and repatriation parts of the process?
I would say that from my perspective, one of the biggest issues is a misunderstanding or a lack of understanding of what Congress intended by cultural affiliation. I don't believe that Congress thought we would be here 30 years later with nearly 14,000 Native American ancestors still in collections that were removed from Illinois. I think that Congress set up a very low bar for establishing a connection between the people of the past and the people of the present. And for many reasons, that process did not work in 1990. And we now today have inherited these collections, which are seemingly unidentifiable. But in reality, if we were to step back and really reassess cultural affiliation the way that Congress intended, we would resolve so many more collections and overcome that barrier and overcome the large number of remains that are still pending in this process.
Can the general public inform you, presumably the National NAGPRA office, if they know of a collection that is violating the law? Are there any museums that have been fined or otherwise punished for violating the law?
Sure. Yes. So there are civil penalty provisions under NAGPRA, which means that any person can allege that a museum has failed to comply with the provisions of NAGPRA. Any person can submit that allegation to my office, and those allegations are then investigated and assessed by the Assistant Secretary of the Interior that I report to. So it's not me or my office that makes those decisions, but an Assistant Secretary, higher level in the department. And yes, there have been several findings of failure to comply by museums based on allegations.
Archaeological collections, especially at universities, have a particular legacy of long-term neglect and lack of funding to bring curation and cataloging up to modern standards. Could you speak at all about what resources might be available for funding outside of the university itself?
Sure. So since 1994, the federal government has provided funds for consultation and documentation of NAGPRA collections. Every year, we award over $1 million in federal grant money to support this work. So that is certainly an option. There are certainly other resources available for universities, but I would encourage any university to look at repatriation as a way of alleviating an ongoing curation requirement. So if there is an opportunity to consult with tribes to use federal grant money, say, to host consultations that ultimately lead to the repatriation of collections and the transfer, that could alleviate the museum of the need for any additional cataloging or curation work that might have not been done. I will say that NAGPRA, this is a quote from a museum director on what NAGPRA did, and NAGPRA really, in many ways, has required museums to do what they should have done all along, which is to know what collections they have and where they came from. But if you keep in mind that the goal of that effort is to facilitate repatriation, maybe it can help to reduce the burden on museums for that catalog and curation work.
Could you talk about how NAGPRA interacts with state laws and especially burial laws across the US?
It's a great question, and really it is up to each state to ensure that it understands the connection between the state law and the federal law. From the federal perspective, we're happy to provide information to states, to state attorney generals, to other people who may be investigating this question on the intersection. But we at the federal level cannot be an expert on state law. We can certainly read it, but it's up to the state to determine how it's interpreting its law and how that meshes with the federal law. So certainly it's an important thing to look at. On our website, we did a webinar several years ago about the intersection between state law and the federal NAGPRA law. That might be useful. We gave some examples of states where attorney generals have issued opinions on how state law and federal law work together. So there are examples that you can find in doing that analysis, but really it's an analysis that needs to be done at the state level. If there's anything that we in the federal government can do to help, we're happy to do so.
You mentioned this a little bit a couple questions ago, but could you be specific about what the consequences might be for a museum that was not compliant?
Sure. So yes, if an allegation of failure to comply is found to be substantiated, then a museum could be fined. There's a base penalty amount, but that penalty could be increased or it can be mitigated depending on the circumstances. So there are many ways in which a penalty could be calculated if a museum has failed to comply, and that amount can be significant. I will say that in general, it is the policy of the Department of the Interior that the goal in any civil penalty is not to raise money, not to increase fines, but to ensure compliance and to enable repatriation of those collections. So really any effort that a museum can make to mitigate whatever failure to comply it might have made in the past can go a long way towards resolving any allegation or potential failure to comply.
One of our attendees points out that there are at least 5 federal agencies in Illinois who control ancestral remains, and how are federal agencies held accountable under the law?
Another good question. So civil penalties cannot be applied to federal agencies. That civil penalty provisions only apply to museums. Federal agencies are subject to what's called the Administrative Procedures Act, which holds federal agencies accountable for complying with laws and regulations. So if there was a federal agency that was not doing the work that it should be doing under NAGPRA, there is a process by which an interested party, in this case a tribe, could sue the federal agency under the Administrative Procedures Act. However, I would say that that might be an extreme approach, and another effort would be to ensure that both the federal agency and the federal agency's administration is aware of whatever is not being done. And certainly there are opportunities to be sure that letter writing or other means of communicating with the federal government to ensure the federal government is upholding its responsibilities. I will say though that there's another opportunity here, and this is what we've seen in several states, and that is for state and federal agencies to work together to come up with solutions to the problems that they both face in doing repatriation work. One of the best examples of this is in Colorado, where the Colorado Commission on Indian Affairs, the state agency, along with History Colorado, the state archaeologist's office, worked together to develop an MOU with the federal land managing agencies to allow them to proceed with repatriation and reburial more smoothly and easily for anything that came from Colorado. And that's been really a fascinating model to look at, how state and federal agencies can work together along with tribes to resolve some of these issues.
Does Nagpra cover remains from outside the US?
No, NAGPRA defines Native American as being those human remains or cultural items that are indigenous to the United States, meaning a geographic United States. So the 50 states and the District of Columbia. It does not include the territories.
Can you talk about how institutional relationships impact NAGPRA responsibilities? For instance, a case where one institution houses objects on behalf of another one.
So when you started that question, I thought about relationships between tribes and museums, but I think the question is actually about relationships between museums. I think that there, again, is an opportunity here for museums or parts of the same overall structure to recognize that what they have in common and how they can work to support each other by keeping in mind what Congress said the goal of NAGPRA is. And the goal of NAGPRA is not to divvy up responsibility or to ensure that everybody's doing what they're supposed to be doing. It's to facilitate repatriation. And whatever different entities can do to ensure that common goal is being met is what I would recommend. We certainly had many examples, speaking of federal and state collections, of efforts to do joint notices and joint repatriations, so that there's not a lot of time or effort needed to parse out which piece of the collection goes to who, but rather with the goal of repatriation to work together. And I would say that's certainly an option for entities within the same state, or for that matter, entities that share a collection. If there are parts of a collection that are spread across the United States, there's no reason why all of those museums couldn't work together to make that repatriation together.
Can you talk about how repatriation to non-federally recognized tribes works under NAGPRA? Is federal recognition required?
Another good question. NAGPRA does prioritize and recognize that federally recognized tribes have standing under the law and under NAGPRA. And that is particular because as a federal law, under the purview of the Secretary of the Interior, there is a requirement for that relationship between the federal government and those federally recognized tribes. That doesn't mean that non-federally recognized groups haven't participated in this process or aren't eligible to receive repatriations directly. It's certainly an option, and there's a certain process to achieve that. However, to achieve repatriation or transfer to a non-federally recognized group, there needs to be a clear effort to consult with the federally recognized tribes, and then an assurance to the Secretary of the Interior that there's no objection from those federally recognized tribes. So certainly federally recognized tribes have precedent and standing in the first place for repatriations. But if they are unwilling or unable or uninterested in proceeding with the repatriation, there are options for non-federally recognized groups.
If a state of Illinois project benefited from federal funding, how would NAGPRA apply in that situation?
Again, the nexus here is not the federal funding so much as it is who has control of the land from which the remains were removed. How that would work out would really depend on state law and what occurs to collections made from land controlled by the state of Illinois or by private citizens in Illinois. The connection to federal funding in this case does not make a difference. The issue would be if the collection is from federal land or land controlled by a federal agency. And that would be the decision that, again, would need to be made by attorneys, either for the federal agency or for the state, to identify who has those responsibilities. In general, though, there would still be a NAGPRA requirement. In the case that these are not from federal land, then the process under state law would very likely trigger NAGPRA once that collection is deposited in a repository or a state museum.
We have an interesting question about images and artwork. This person cites an example of an image that was made about the AIDS crisis using an image of the burial site at Dixon Mounds. So how does image use fit into NAGPRA, or does it?
It's a very good question. There is no specific requirement in NAGPRA or prohibition against imagery of Native American human remains. However, I would say that the use of imagery can be incredibly damaging to relationship building. And so any museum would want to think carefully about how it was using images that it might have of Native American human remains, or how those are distributed publicly, because those can be quite sensitive issues. But there's nothing in NAGPRA that would prohibit it. And there's certainly nothing in NAGPRA that would keep a museum from taking images of its collections and using them in some way. NAGPRA does not prohibit any kind of documentation or research, but it is important to remember that NAGPRA does not require it. So this is again where we get to the discretion of a museum to determine what its own policies are going to be with regards to images, research, documentation, and then what might happen with those afterward.
There are many examples where one organization transfers collections to another because they don't want to be involved with NAGPRA. Is this a concern?
Well, I would say that it would be important for an attorney to assess the risk to a museum in doing a transfer for the explicit purpose of avoiding NAGPRA. Certainly, it is a failure to comply with NAGPRA, and you could be subject to civil penalties if you were to transfer a collection for the purposes of not having to do NAGPRA. That is a failure to comply. Certainly, it's a failure to comply to transfer to somebody who does not have NAGPRA obligations. However, there are certain cases where it has been actually advantageous to repatriation for those transfers to occur. And I'm thinking in smaller cases where, say, a small museum has a collection and there's a larger piece of a collection at a larger museum, transferring to that larger museum for purposes of facilitating repatriation are certainly allowable and again, a good faith effort on the part of the museum. And this is really why an attorney would want to be consulted, because NAGPRA does depend on museums making good faith efforts. So in making a transfer, a museum would want to be sure that it was wondering and examining whether or not that was being made in good faith.
Our next question says, there are many museums and institutions in Illinois that are grossly non-compliant with the law and therefore continue to cause harm to Native nations. In your opinion, what's the best way for those museums and institutions to become compliant with the law?
So I often get asked about compliance, and I need to be very clear that until there is an allegation of failure to comply and a finding that there is a lack of compliance, it's not my place to assess compliance by any museum. Compliance means that a museum has filed its inventory and summary in accordance with the deadlines, and that a museum is responsive to any request to consult. Again, if you think back to the presentation I gave, compliance are the musts that I presented. There are a lot of mays. There's a lot of discretion on the part of a museum and how they're going to carry out this process. And exercising that discretion does not mean that a museum is not in compliance. However, I would say that there is an advantage to a museum to being more proactive. Again, there are obligations to consult upon request. If a museum chooses to proactively consult with tribes, they alleviate themselves of that responsibility. If a museum proactively attempts to establish relationships with tribes and has a good working relationship, that could prevent the future allegation of failure to comply by a tribe for a museum that is refusing to consult or refusing to repatriate. So I think there are advantages to considering whether a museum is acting in strict compliance with the law or is exercising its discretion in a way that takes advantage of the opportunities. And so in that case, I would say to any museum that's questioning its compliance, the best thing that you can do is start talking to people. And the first people to talk to are the tribes that may have an interest in your collection. Talking to your own attorneys is probably also a good idea to ensure that you're proceeding in a manner that protects the museum. Talking to me in my office is a great way to get started. Talking to other museums who've confronted the same issue is a great way to figure out how you're going to move forward. If you don't know, there is a growing community of practice for NAGPRA practitioners that started out of the University of Denver under a museum leadership grant through the Institute of Museum and Library Services. And that's a wonderful place to find other people who are struggling with similar issues and to figure out how they've confronted those issues.
Could you talk a little bit about the intent to repatriate versus the intent to affiliate?
Sure. I think that probably the question is getting at a question of whether you're going to repatriate or transfer versus approaching from an intent to just affiliate a collection. What I would say is that you have an obligation to do both. So any museum that has Native American human remains that are currently not culturally affiliated has an obligation to consult with Indian tribes and to assess cultural affiliation. If cultural affiliation can't be determined, then that museum still has an obligation to transfer those collections and to offer them to tribes based on the current regulatory process for Aboriginal land. So there is under NAGPRA a requirement to facilitate repatriation or transfer either through affiliation or through other methods like Aboriginal land. There is an easier path, I would say, through affiliation. And I would say that approaching consultation with a view towards affiliation is a good way to start the process, because it is a requirement that the museum assess that decision that it might have made in the past about affiliation. If the question is a little bit different and maybe is about objects rather than human remains, when we're talking about sacred objects or objects of cultural patrimony, repatriation is dependent on cultural affiliation. So there is a need to identify cultural affiliation of any object separate from the human remains question. Those objects must be affiliated in order to be repatriated.
This question is not specifically for you, Melanie, but one of our participants asked if a recording of this event is going to be shared with our participants. And the answer is yes, we are recording. So if you are an employee of the university or of the Illinois State Museum, we will make the recording available to you administratively. But if you are another state employee, for example, or from a different institution, please email us at nagpra@illinois.edu and we will make sure that you get access to that recording. That's a great question. Thank you for asking. Our next question for you, Melanie, is what do you think is the greatest barrier to resolving pending cases? And this might be one that you already answered when you talked about cultural affiliation, but in case it's not, we have that question for you also.
I think that the greatest barrier to completing the work of NAGPRA is a really fundamental question of whether there's a will to repatriate. I think that if there is an objective on the part of the museum, a mission or a commitment to repatriate, then there's a path for it. But if the museum does not have that will or does not commit itself to that objective, then it can be a barrier. And that goes along with affiliation, but I think it's a little bit different. I heard someone explain an approach to NAGPRA that really resonated with me, and that is there are basically two ways of approaching NAGPRA. One is, do I want to repatriate or not? And the other is, who am I going to repatriate to? And those are fundamentally different questions. And so how you approach the questions, which side of that you start from really depends on, ultimately results in whether or not you get to that completed repatriation or not. So I think that there are other barriers to repatriation, and those can be both institutional structures that may prohibit repatriation. There could be financial barriers, staffing and funding to enable consultation and work on collections. But I really think that regardless of any of those other barriers, if there's a will, there's a way when it comes to repatriation. If there's a desire on the part of the institution to repatriate, then there's generally a path forward.
So you mentioned already that federal agencies and the Smithsonian are subject to other laws that are not NAGPRA, but do they also provide information about their holdings?
Yes, so federal agencies have the same requirement for identifying and reporting on collections. Federal agencies also have requirements for notification of collections that are made on federal land. The Smithsonian also has some reporting requirements. They are less, I think, less publicly available than the NAGPRA reporting, identification or reporting information. But the Smithsonian is required to file a report to Congress every year on its repatriation. That includes information about the numbers of collections, the number of human remains, and then the numbers of consultations and repatriations that have occurred.
We talked about one side of this question a little bit already, but what about remains that have been sourced from within the US but are now housed internationally?
Right. Yeah, I didn't quite get to that side of the question. So NAGPRA is a US law and can only require repatriation by US institutions. There are a couple of exceptions to that. We have seen cases where foreign institutions might have done field studies or collections on federal land. And in that case, those collections, even if they were taken back to a European university, for example, would still be US federal property, and the federal agency could then reclaim those collections and repatriate under NAGPRA. We have seen, though, over the last few years, a growing effort by foreign museums to voluntarily repatriate collections. Just a few months ago, there was quite a large repatriation that was conducted from the National Museum of Finland of collections that were made at Mesa Verde National Monument in Colorado. And those collections taken from Mesa Verde by a European national back to Europe in the 1880s had no connection to NAGPRA and no requirement for repatriation. But the National Museum of Finland decided to make a voluntary repatriation of those collections. And they were not only returned to the United States, but then reburied within the national park at Mesa Verde.
You already mentioned a little bit that National NAGPRA provides consultation and documentation grants and repatriation grants, but are there any other ways that you're aware of that repatriation work is typically funded either at the museum or the tribal level?
Well, again, I would say that some of this comes down to the priority for the university or the tribe in where they're going to put support and financial resources. So, you know, I would say that there are probably any number of opportunities for universities to raise funds, to support this work. And, you know, I think any of those should be explored in terms of building support for carrying out this work and conducting this work. I know that I can't really identify any other sources of funding necessarily beyond the federal grant program that I oversee, but I'm sure there are other resources available for supporting this work.
One of our participants is interested in your graphic about how groups from 5,000 years ago might be reasonably associated with multiple current groups. If a museum wants to be proactive versus just responding to a request, should they reach out to all current groups? And what if there isn't agreement about the outcome?
Great question. So there doesn't need to be an agreement for a museum to finish its work on the process. A museum's responsibility is to identify those tribes that are likely culturally affiliated, meaning that there's a reasonable chance that the present day people are connected to the past groups or past peoples. And we have seen very large cultural affiliations by many institutions, and that there's no prohibition to that in NAGPRA. The museum's responsibility here is to identify all of those tribes that have a right to request these remains by identifying all of those that have a shared group identity to those past groups of people. Once the museum does that, it's then up to the tribes to figure out what happens next, whether there's going to be one request, whether there will be multiple competing requests. That issue is not addressed until after a museum makes its initial decision about cultural affiliation, which is why it's so critical that museums take on that work, that museums shoulder that burden that Congress put on them in the first instance to identify all those tribes that are eligible to make those requests. Once those competing requests or additional requests come forward, then there's a process built into for a museum on how to resolve them. But until that happens, I think there's a little bit of putting the horse before the cart before the horse in anticipating a conflict or anticipating a problem. Because what we've seen by and large is that tribes, even when there is deep conflict between different groups, a lot of times those tribes will put that aside in in an effort to repatriate and to get the ancestors reburied. And this happens many, many times in many, many states where the conflicts are resolved in a positive way so that the repatriations can occur.
Can you speak a little bit to, excuse me, the ethical and human rights aspects of repatriation? As you mentioned, the NAGPRA bar was set fairly low so that it was achievable. It seems that we need to go so much further than just meeting a bar where the museums or universities hold so much of the decision-making power.
Well, my responsibility is in carrying out the law and to helping people understand what their requirements are under the law. Sometimes I compare it to a four-way stop. You know you have to stop at the four-way stop, but there's nothing in the law that tells you need to let the other car go first if you have time to spare. That's a decision you have to make for yourself and how you're going to conduct yourself in your life with that four-way stop. The same thing goes for NAGPRA. I think that I would not speak to ethics or the ethical responsibilities of museums, because what I need to speak to is what is required of museums. And absolutely, under the law, museums have a lot of power in decision-making and how they're going to carry out this process. And I would look to professional organizations or other places for guidance on ethics, on relationship building, on the mission of a museum, and how best to carry out that mission through approach to repatriation.
In some cases, you've mentioned human remains, and in others, you follow that up with cultural items. Are these one and the same, or are they approached differently?
So as I think I mentioned, certainly the law prioritizes human remains and their associated funerary objects. There is a higher standard of reporting and transparency on human remains, in particular because Congress did identify that human remains of any ancestry should be treated with dignity and respect. However, technically under the law, cultural items means everything under NAGPRA. It means human remains, funerary objects, sacred objects, and objects of patrimony. So cultural items is the broad overall category that could be used for any object that is subject to repatriation under NAGPRA. But there is a distinction in the law between human remains and their associated funerary objects, and then the other categories of cultural items.
We're actually now caught up on our questions. So we'll give people just a second if you have any last minute things that you'd like us to ask. Otherwise, we will wrap this up. So last minute questions, here's your last call.
I don't know if we have any students participating today, or I would like to say to anybody who's entering this world and thinking about careers or future paths, one of the most important things I would recommend to any student or any professional is to take a look at our public information, our online databases, and to see where institutions are in their NAGPRA efforts before you decide to commit yourself to that institution or that museum. It's important to identify who is doing this work, maybe who has a lot of this work left to do, but also where you might find like-minded people if you are wanting to engage in repatriation work.
We did have one last minute question pop up, so we'll make this our last one because I think we're technically over time anyway. The state burial law in Illinois is not administered by the SHPO. So knowing that, can you speak any more to what responsibilities the SHPO may or may not have?
Sure. Ultimately, I guess I would say that whether it's the SHPO's responsibility or another office under the state government, the state has the responsibility. And therefore, the state needs to be sure that it's coordinating its efforts across its different agencies and offices to carry out that responsibility under state law and to ensure that those that it's being carried out appropriately. I will say that for the SHPO, you know, there may be obligations based on the National Historic Preservation Act or other conditions associated with the SHPO's office in ensuring protection of archaeological resources within the state and other obligations that might come through that SHPO's office that would impact or coordinate with whatever the state burial law and state burial process is. So ultimately, I would say that just as I ultimately carry out all my responsibilities on behalf of the Secretary of the Interior and the President of the United States, anybody who works for the state of Illinois is carrying out those responsibilities on behalf of the governor and the state legislature, and therefore has a connected responsibility, if not a specific one.
Thank you so much for all of your questions, everybody who came to be with us this afternoon. And thank you so much, Melanie, for your presentation. It'll be really wonderful to share it with our colleagues who are not able to make it this afternoon. So if, like I mentioned earlier, you would like access to the recording and you're not sure if you'll get it directly from your supervisor or whoever invited you to the event, please feel free to email us at nagpra@illinois.edu and we will get you on the list for access to that recording once we make it available. So thank you very much, everybody, for joining us today, and I hope you have a wonderful rest of your Thursday.